today's topic, we will covering Lesson 1.3, Federal and State Legal Systems found in our Business Law textbook. The goals are to name the 3 levels of federal courts and to identify the various types of state and local courts as well as their jurisdictions. The federal courts, U.S. District Courts, Federal Courts of Appeal, the U.S. Supreme Court. At the lowest level of federal courts with general jurisdiction is the U.S. District Court. This is the trial court of the federal system. A trial court is basically a court in which a case is fully heard for the first time. The power to determine the facts of the matter and to make the initial determination of the law to be used in deciding a case is called original jurisdiction. The district courts have that power in the federal system. In general, district courts have original jurisdiction over a. Federal questions, which are cases that arise under the Constitution, U.S. law, and U.S. treaties, and b. Lawsuits between parties with diversity of citizenship, which means between citizens of different states, between a U.S. citizen and a foreign nation, or between a U.S. citizen and a citizen of a foreign nation. Significant lawsuits involving citizens of different states are placed under U.S. District Court's jurisdiction so as to avoid any bias a state court might exhibit toward its own citizens. In all diversity cases, more than $75,000 has to be in dispute for the case to be considered significant enough for a U.S. District Court to handle it. If the amount in question is less than $75,000, the case will be tried in a state court with appropriate jurisdiction. The federal courts of appeal have appellate jurisdiction over the district courts, certain specialized federal courts, and many federal administrative agencies. Appellate jurisdiction is the power to review cases for errors of law. Such power is exercised when the result of a case in a lower court is appealed by one or more of the parties to the case. Appellate courts do not accept any new evidence or call witnesses. Instead, they may review the transcript, a verbatim record of what went on at trial. They may also review the written and oral arguments of the opposing attorneys. Note that no appellate court, not even the U.S. Supreme Court, can change the factual determinations of a jury. However, if the appellate court detects significant errors in the original trial, it can order that a new trial be conducted. A new jury then would make a new determination of facts. There are 13 federal courts of appeal. 12 of these are circuit courts, each of which is responsible for an assigned geographic area. The 13th is dedicated to the Federal Circuit. As such, it handles patent and claims cases appealed out of the district courts. It also handles appeals from specialized federal courts and from such bodies as the Court of International Trade and the International Trade Commission. The U.S. Supreme Court, USSC, has both original and appellate jurisdiction. The original jurisdiction of this court is used far less frequently than its appellate jurisdiction. According to the U.S. Constitution, the USSC has original jurisdiction only over cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party. The appellate jurisdiction of the USSC is exercised over cases on appeal from the U.S. Courts of Appeal or from the highest courts of the various states. If, after reviewing, the USSC believes that a case contains a constitutional issue that needs to be decided, it will issue a writ of certiorari to the last court that heard the case. This writ, or order, compels the lower court to turn over the record of the case to the Supreme Court for review. The original jurisdiction of this court is used far less frequently than its appellate jurisdiction. The USSC has original jurisdiction only over cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party. The U.S. Supreme Court, USSC, has both original and appellate jurisdiction. The original jurisdiction of this court is used far less frequently than its appellate jurisdiction. According to the U.S. Constitution, the USSC has original jurisdiction only over cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party. The appellate jurisdiction of the USSC is exercised over cases on appeal from the U.S. Courts of Appeal or from the highest courts of the various states. If, after reviewing, the USSC believes that a case contains a constitutional issue that needs to be decided, it will issue a writ of certiorari to the last court that heard the case. This writ, or order, compels the lower court to turn over the record of the case to the Supreme Court for review. The USSC's appellate jurisdiction over state Supreme Court cases is limited to those in which a federal law has been invalidated, or whose issues center on the U.S. Constitution. The decisions of the USSC that interpret or apply the U.S. Constitution are final and can only be overturned by the USSC itself or by a constitutional amendment. The typical state legal system mirrors the federal system. The state legislature makes the laws. The state executive branch enforces them before the courts of the state judicial branch. There are state administrative agencies with powers given them by the state legislature. These agencies often complement their counterparts at the federal level. For example, a State Department of Natural Resources is a counterpart to the U.S. Environmental Protection Agency. 1. State trial courts. 2. State courts of appeal. 3. State Supreme Courts. 4. Specialized state courts. In most states, the courts with general original jurisdiction over both criminal and civil matters are known as circuit courts. In other states, however, they are named superior courts, district courts, or courts of common pleas. Regardless of their title, they are the courts of record of the state system. In a court of record, an exact account of what went on at trial is kept so that appeals may be filed. This account may include a transcript of what was said, the evidence that was submitted, statements and determinations of the court officials, and the judgment of the court. Courts of record will at times review the decisions of, or handle appeals from, courts of inferior jurisdiction. When this occurs, however, they actually retry the cases in full, in order to make the proper record in case of appeals. Because it has original jurisdiction over a case before it, a court of record will make determinations of the facts in the case by using a jury, or, if a jury is not requested by the appropriate party or parties, by having the presiding judge determine the facts. The court of record will then select and apply the law to the facts to reach a verdict in the case.
In about half of the states, a panel of no more than 3 judges from a state court of appeal reviews an appeal of a case in a court of record. In states where this middle level of appellate court does not exist, the appeal goes directly to the highest state court, usually referred to as the state Supreme Court. The panel from the state court of appeals or Supreme Court evaluates the record of the case, and then hears the attorney's oral and written arguments. Note that no new evidence can be introduced at this level, so the facts remain unchanged. Basically, the appellate judges check to be sure that the correct law was used to resolve the case. The Court of Appeals panel of judges may conclude that the trial court used the wrong law. If so, the panel may enter the correct judgment or send the case back down for a new trial. On the other hand, the judges may conclude the lower court used the correct law in the proper way and, consequently, let the lower court's judgment stand. In general, a party to a case is entitled to a trial and to one appeal if the appeal is filed in a timely manner and in the proper form. As mentioned above, a middle-level state court of appeals handles that appeal in about half of the states. Otherwise, the state Supreme Court handles it. In states with the middle-level courts of appeal, only cases that involve the most complex legal issues are taken to the justices of the state Supreme Court. At the state Supreme Court level, a panel of 3 or more justices reviews the legal issues and listens to the attorney's oral arguments. State Supreme Courts issue the final decision on matters of law appealed to them, unless the U.S. Constitution or other federal issues are involved. In that case, a further appeal can go to the U.S. Supreme Court. In addition to its appellate jurisdiction, in several states, the state Supreme Court has original jurisdiction over most state impeachment cases. Specialized state courts, associate circuit, county courts, municipal courts, small claims courts, juvenile courts, probate courts, other courts.